The courtroom was already restless when Darius Cole stood up from the defense table. No lawyer accompanied him. No paralegal shuffled papers beside him. Just him, a calm man in his late 30s with sharp eyes and a worn leather briefcase, a self-represented defendant. That fact alone had drawn quiet sighs and sidelong glances when the case was called. He stood accused of felony obstruction stemming from a protest outside a state building. A protest that, ironically, called for greater police accountability and transparency. Darius maintained that he had done nothing wrong, that he had a constitutional right to be there and to speak. Judge Elizabeth Harmon, a seasoned jurist in her 50s, peered down from the bench with evident skepticism. When Darius requested time to present a pretrial motion, she visibly rolled her eyes. "This isn't a classroom, Mr. Cole," she said, voice tinged with condescension. "Let's not waste the court's time." Darius remained composed. "Your Honor," he replied, "I believe what I have to say directly impacts not only this case, but the constitutional implications it raises." The courtroom, which had half-tuned out the case minutes earlier, perked up as Darius walked to the podium. He carried a single folder, organized with handwritten notes in the margins. His voice was calm but authoritative. "My motion is to dismiss the charges on the grounds that my arrest violated both the First and Fourth Amendments. I will show that there was no probable cause and that I was targeted based on content-based discrimination of my speech." The prosecutor smirked, whispering something to his co-counsel. The judge leaned back in her chair. "Proceed," she said dryly. Darius began citing case law, Edwards v. South Carolina, Brandenburg versus Ohio, and more obscure rulings involving time, place, and manner restrictions. With each reference, he articulated not only the precedent, but why it applied directly to his case. He presented video footage showing that he had been standing peacefully on a sidewalk, speaking into a megaphone, surrounded by other protesters who were not arrested. The footage showed officers targeting him specifically. He then moved into Fourth Amendment territory, arguing that he was seized without probable cause and that the arrest report was retroactively constructed to justify unlawful policing. The judge's demeanor shifted as he spoke. Her pen began to move. The prosecutor's smirk faded. "Mr. Cole," she interrupted, "are you a trained attorney?" "No, Your Honor," Darius replied, "but I studied pre-law before changing careers, and I've spent the last 9 months preparing for this case. I know my rights, and I'm ready to defend them." During cross-examinations, Darius's questions were tight and tactical. He asked the arresting officer about inconsistencies in his written statement and got him to admit that the crowd was not violent and that no dispersal order had been issued before Darius was detained. "You knew who I was, didn't you?" Darius asked. "I'd spoken at a community forum 2 weeks earlier, challenging your department's budget proposal." The officer shifted uncomfortably. "I can't recall." "You can't recall, but you remembered me well enough to arrest me out of a crowd of 30? The silence in the courtroom was deafening. By the time closing arguments came around, Darius no longer seemed like the underdog. He laid out a closing that could have been delivered from the floor of the Supreme Court. "This case is not just about my right to protest. It's about our collective right to speak truth to power without fear. If our courts cannot recognize that, then the Constitution is only ink." The judge recessed for deliberation. When she returned, her tone had changed. "The court finds that the charges against Mr. Cole are unsupported by sufficient evidence and are hereby dismissed. The court also recommends a review of police protocols during public demonstrations." Darius exhaled deeply but showed no visible emotion. He gathered his things, thanked the judge, and walked out. Past reporters, past curious onlookers, past lawyers who now knew not to underestimate a man who studied law not for a degree, but for justice.